So I'm Sophie Lenz, as you could have guessed, I'm not Hans, and Hans Verstrepen is here, well, next to me, just behind the computer, and we will share the presentation of this fourth IP update webinar, and so you will just see him whenever it's turn to speak. So for now, it's up to me. Here, first thing first, I will start with a little overview of how the presentation will be divided. It's quite simple. We will really try to give you a really general overview of trade secrets so that you really know what you are dealing with and that you will really be prepared. So the title was really a good hint of the structure of the presentation. So the first section that we will go with is time for basics, is that if you don't know what you are talking about, then there will be a problem. So we will just simply go and see some definition. Don't worry, it won't be too theoretical, but it will go quite fast, and it will be quite simple over trade secrets and the general and main notions that you need to know when we are talking about trade secrets. Then the second point, and it's still to be sure that you really well understand what is a trade secret, is that we are, and actually it's not we, it will be Hans, we'll be discussing about the difference between trade secret and intellectual property rights, because some people, and even in some country, to be fair, confuse trade secret and intellectual property and things that they are, the same, but they are not the same. They may be two faces of the same coin, but they are not the same faces, that's for sure. Then in a third section, we will, and still not we, but still Hans, will go over the reasonable step to be taken to create and to maintain a secret. And as I will have explained you in the first section, this notion of reasonable steps to take to maintain a secret is one of the main conditions in order for you to be able to say that you have a trade secret and then to try to protect that trade secret. And then in the last section, and here I can say we and I can say I will be talking about the measures available in case of infringement. So it is more a judicial section. We will briefly go over the judicial action that you can invoke in order to defend, well, I was going to say your right, but it's a little mistake, because trade secret is a right, but it's not intellectual property right. So in order to defend your trade secret in case of misappropriation thereof. So let's start with the first section. So what is a trade secret? So a trade secret, and for those who have maybe followed some of the previous presentation we have made, or other presentation, or those who have followed a little the news over the trade secret directive that came out in a few years ago now, it is 5 years now, and then the Belgian law that implemented that directive, maybe you will recognize that definition, because that definition is a definition that comes from the directive and that was just taken over, copy-paste by the Belgian legislator. And it might, seems quite, that's just a definition, but it was quite a good news that we finally had a definition, because we have gone through, for many years without a definition of what was a trade secret. And when you don't have a clear definition of, a notion, then you don't know what you're talking about, and in the case law, it was not always easy to know what we were talking about. So now we have a definition and we stick with it. So the trade secret is an information that will have to fill in 3 cumulative conditions. What are those conditions? First of all, surprise, it has to be secret. We will go a little further on that notion in a few minutes. Second condition, this trade secret, this information that is secret, has to have a commercial value because it is secret. And that is really important. That second part of this sentence is really important, because it is secret. We'll come back to that also. And then the third condition, so don't forget it's a package, cumulative conditions, is that this information that is secret and that has commercial value must have been subject to reasonable steps. You will remember that is the title of one of the sections that Hans will go over. Reasonable steps under the circumstances to keep it secret. And as you will see, as always in law, every word has its importance. So first thing, the trade secret is an information. Okay, good to know. So what kind of information? any kind of information. So it's really easy. And for this, there was a discussion over that if we had to kind of restrict the kind of information that could be covered by the notion of trade secret and that could be protected under the notion of trade secret. You know, should it be commercial? Should it be technical? Should it be only linked to specific factories and so forth? But it was decided under the directive discussion that it would cover any kind of information, because we shouldn't limit from the start the kind of information that could possibly enjoy the trade secret protection. So you start with an information, and that information, you know, in principle, can be protected if it fills all the conditions as a trade secret, regardless of the mode of expression or regardless of the medium. So whether the information is only stuck in a computer, whether it's on a paper, whether it's some kind of only an oral expression that passed, you know, from brain to brain. In principle, it could be protected information. It could fill in. It could be a trade secret. And here we have taken a few examples. I'm not going to go through all the examples, but we have taken a few examples of what kind of technical information could be considered a trade secret, what kind of commercial information could be considered a trade secret. And the first technical here information that we have identified, it will be a good link to the next section. So not right now, but in a few minutes when Hans will go over the difference between trade secrets and IP right, because you have here the first information that could be protected is unpatented or unpatentable invention. So the unpatentable invention is quite simple. If it cannot be patented, then of course, well, keep it secret because you couldn't have a patent. But you see, unpatented, you could decide that maybe it could be patent, but you would not go for a patent because maybe it would be a better idea for you to keep it secret. So that's exactly over that kind of strategy and decision that Hans will go over with you in a few minutes. So you see algorithms, recipes, chemical formulas, plans, drawings, the recipe for KFK's special thingy that covers the chicken. A few years ago, it was the Big Mac sauce, but I've heard that Big Mac sauce now is not a secret anymore, so it was really disappointing. Also a recipe for Channel 5, you know, any kind of perfume, the materials of which is made, the Michelin pneu. I lost the word in English, sorry. So any kind of information could at first view be covered. So let's go to the second, the first condition when you have this information is that this information has to be secret. And here I reproduce the phrase, the sentence from the law, because it's quite, you have to take take this sentence and really precisely understand what it means. So the secret is something that it is not as a body or in the precise configuration and assembly of its components generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question. So a lot of elements in only one sentence to say that the information has to be secret. So first of all, it may be that some elements of the secret are not secret as such, but if the combination of all these elements together is a secret, then it could be considered as a trade secret. And then, sorry, I see movement around me, it's the crew, you know, when you work with such a big crew. And then the second element for it to be secret is that when you say generally, it means that if only a few people in the world know the information, it won't kill your secret right away. So you can have a few people knowing it, but still being able to establish there is a trade secret. Then it must be readily accessible. So it could be accessible, but if really the person had to go through the most enormous effort in the world to get information, we couldn't say, and the person in question couldn't say it was readily accessible. And then last, and it's kind of a link to the condition of readily accessible, is the presence of an internet. Today, it's almost possible to find anything of the internet when you really look deeply and you take the time to look. So the sole fact that it could possibly be found on the internet after hours and hours and hours and hours of research wouldn't mean that it is necessarily readily accessible. So it's always a question of facts and of assessment in case by case. And then still analyzing this sentence, which is really long, is the reference framework is the interested circle. So for those of you who are more familiar with IP rights, you will see it and with patent, it may also ring a bell. And then the last part that is important to know is that it is not required in order for the secret, to be secret and then to be able to be protected, that information has been used or applied as such. So the sole fact that the information exists, that is secret, can in principle be enough. Then a little practice. So what in practice? So you have the definition of what is a secret and when can it be considered as being a secret. But of course, you always have to go and make an assessment case by case. Always, always, always. And here we have taken a few examples, only 4 examples, but there are more in practice of what has or has not been considered as being a trade secret by the courts. But beware, it's not because here you will have one answer, for example, for general accounting data, that you will find the same answer in another case also concerning general accounting data before another court. So it will always be a case by case. So here it's really only something to illustrate, but don't think that because here the court gave a specific answer, it would be the same answer in another case. So for example, general accounting data that are fed into an online application, it was a company, well, they had an online application that was fed, well, quite logically, with accounting data that was from the internal from the company itself. But an ex-employee had access to that application and actually took information and give access to that information to another company. But then it was said, the court said that the information in itself was not secret because the information that fed the online application was also used and to be found in clients' invoices. And the court considered that for the competitors that were well aware of what the sectors worked and that they knew who were the potential clients of this company, they could have go and contacted the clients and they could have come up and discovered information themselves, so without having access to the application. So the court considered that, ta-da, it was not a secret. So a second example is the specific way of connecting and assembling starter machines in a manufacturing line. It was about a big company in Belgium that was busy with recycling stuff, and they bought machines, and sometimes they made machines were really made well, not by hand, but really on measures, as we say in French, and then they will connect those machines in a specific way and assemble them in a specific way. And it's quite a big machine, so as such it was not in a building, it was outside, but in a specific area that has that was grillagé. That's an hard word for me to say. Well, so there was not huge walls over the place, but the company made his best to protect in a reasonable way those machines from the view of the people outside of the manufacturer. And the court considered that, yes, the way that you assemble those machines could be considered as a secret as such. Okay, so in another case, maybe it could have gone exactly the other way. And then we go to the French border, not the French border of the language in Belgium, but the French border, like really the French in France. Where we had here 2 cases, and it's funny because it's 2 cases about a list of countries that were produced to some competitors, and in one case you will see that the decision were exactly the opposite, because in one case, the first one, the court, the TG, the Tribunal de Grande Instance of Paris, said that the list of countries in question were not to be considered as a secret, and notably because this list of countries was also produced within another procedure that has been ongoing in France, and that it has been kind of made publicly accessible in some way so that it couldn't be considered as a secret. Whereas in another case, the court, also a court in Paris, not the same, said that also a list of countries were containing some specific also information, including client names and stuff, could then be considered as being a secret, because contrary to the other case in Paris, here the information was not made accessible to the public, and it was not readily accessible to the public. So that brings us to the second condition in order for you to be able to invoke and then to protect a trade secret, is that the information, once you have established that it is secret, has to have commercial value, but not commercial value for any reason, because it is secret. And really, I insist, it is really important, because in some case you will have some sensitive information that could be considered as a secret, that could be shown, but I'm messing up an information that could have commercial value, but the commercial value has really to come from the fact that the information is secret. And if you don't have that link between the two, then it won't satisfy for being a trade secret. Commercial value is what? Is that the information must in some way, and there is really no clear definition. So once again, it's a case-by-case basis. This information must be likely to improve your competitive position compared to your competitors. So the sole fact the information for you has some kind of intrinsic or sentimental value is of course not sufficient, but the fact that it could give you a competitive advantage over your client, that would suffice to establish commercial value. The value can be potential, can be real. So you don't have to prove to the court when you're court that it has actually brought you some kind of financial counterpart or some kind of real tangible advantage. The sole fact that you can show that it could have give you an advantage or it could give you in the future is sufficient to consider that it could have that it has commercial value. And so what are the indicators? It's always, and you will hear me say that every slide we go through, it's a case-by-case analysis. And so here we have put some indicators of what could help you to establish that you have a commercial value, that your information has a commercial value, is that, so the competitive advantage, we just went through that, showing, for example, that you tried that, you know it didn't work, you will keep that secret, and you know why it gives you a commercial advantage over the competitive advantage over your competitor is because you took the time to do it, you took the time to try it, but the competitors will have to take the same time to try it, and if he knew that it wouldn't work, it would make him save time, so it's a competitive advantage as such, for example. Then also, if you can show that it was a big investment to get this information and to keep, so not only to obtain it, but also to keep the information secret, that could be also an indicator of commercial value. If people have paid you to have a license over that information that we are considering as a trade secret, if they have paid, to obtain it, well, it shows in some way that at least in other people's eyes, this information does have commercial value. And also, is the information under consideration, is it difficult to find? Was it difficult to obtain? Is it difficult to reproduce? All those indicators will potentially help you to establish that the information has commercial value. So in practice, so now you know it works, it's case-by-case analysis, as always. So let's come back to this setup of the manufacturing line in this big Belgian company, busy in recycling stuff. So we have seen that the court considered that indeed it could be considered as a secret because information was sensitive and could be secret here in the specific case. But does it have commercial value as such? And I'm pretty sure from what I'm said from the when I analyzed this case before, you will know the answer. Yes, it have commercial value as such, because once you had taken the time and the money to put all the machines in a specific way, and you see that it works better than when you put it in another way, all this time and all this money, it's of course commercial value for you. And if your competitor knew the information, he wouldn't have to spend the time, to spend the money to discover exactly what you discovered. So yes, it has commercial value. Then enhanced extraction method. To be honest, I don't remember on what was the method applied. Sorry, but yes, that's quite easy here. It has commercial value because the extraction method was really an optimization of what existed before. And so yes, it gives you a competitive advantage over your competitors to know or to extract better these materials, of which I forgot the name, quicker, better, in a more appropriate way than your competitors. Then the general accounting data that is fed into the online application. So for the one whose we have said it was not a secret here, the court considered that not only it was not a secret, but it was not, it didn't have commercial value. But here, for what reason? As such, the information that was under consideration could have commercial value, but the court insisted that the condition was not only to have commercial value, but to have commercial value because it is secret. And here, the two conditions were totally interlinked. Because it was not a secret, it could not have a commercial value because it was secret. So the first condition just made the court decide. The second condition is certainly not met here. And then the last example we have is also a company, problem between a company and one of the ex-employee that went to the competitor, and the ex-employee took, well, some emails, a lot of emails with him on its personal computer, and showed some of his email to his new employer, so the trade secret holder competitor, and the trade secret holder said that having access to these emails, was a big breach, big misappropriation of his trade secret, but because in those emails that were accessed, he said some kind of bad stuff about the competitor. Then he said why he thought that the competitor's products were not working, but the court said it was not to be considered as having commercial value as such. It was just the expression of opinions, and the court also added that not only the few specific emails that were under consideration were not had not commercial value as such, but that the 1,000 other emails that the alleged trade secret holder invoked couldn't even be taken under consideration by the court, because the alleged trade secret holder was not precise enough as to what email was to be considered and what information within this email was to be considered as a trade secret. So always be careful to be really precise also. And that brings us to a last condition in order to have a trade secret, and that's the reasonable steps, which Hans will analyze a little more practically in a few minutes. And so I will just go really quickly, is to have, you have to take the reasonable steps to keep an information secret. When I say you, is a trade secret holder, and the reasonable step is too reasonable under the circumstances. So it's always, once again, on a case-by-case basis. So all the type of company don't have to take exactly the same measures for the different information. So it depends on the nature of the information, it depends on the size of your company, on the financial means of your company. It depends on the kind of sector of activity, on the cost that should be put on the table and stuff like that. And then in practice, if you followed me, you know that you have to wait for Hans to come back. Then, really quickly, the trade secret holder, it's really the large general definition. It's any natural or legal person that is lawfully controlling a trade secret. So it's a really broad definition. So any person can be, at first view, a trade secret holder. And when we say lawfully controlling, it's also quite broad, a notion. So be aware that a license holder, if the license is legal and everything is in order, could be considered as being lawfully controlling the secret. So when you have a license over a trade secret, always be careful to insert in the license some kind of limitation as to what can the license holder do with the secret. And if you don't want the license holder to be able to sub-license, put it in the contract, because you can have bad surprise over that. Also, the lawful acquired by reverse engineering. If you have a product, it's easy to reverse engineer. You get information that was, hidden within that product. Lawful controlling, because it didn't do anything unlawful. So if you don't want to be in that situation, also always put a clause forbidding and preventing people from reverse engineering your product or whatever it is. And then the last two is that the directive and now the law also defined infringing goods. And so I'm not going to read the definitions. It's, well, any kind of goods that benefit significantly from a trade secret, and that was misappropriated, of course. And then the infringer, you have here a nice distinction that you don't find so clearly for the IP rights. You have the direct infringer, the person misappropriating the secret. You have indirect infringer, which is who is expressly also defined as a person who participated, but not directly, but who knew or should have known that the secret was a secret first, and that it has been misappropriated. And also the person surrounding the infringing goods, so the importer of the infringing goods will be also considered as an infringer. And I said last, but it wasn't last, but that goes really really quick, is for the infringement. Well, you have just to be careful, because compared to an IP right where you have an infringement as soon as you don't have consent, here, even if sometimes you don't, of course, everything that is done with consent is lawful, but here, even if you don't consent, you may have some kind of appropriation that will not be considered as unlawfully, because it was lawfully acquired for reverse engineering, for example, the independent creation and so on. So it's only a protection against unlawful acquisition, use, and disclosure, and the law specifically identifies some lawful acts. So that is it. And I pass the word to Hans.
Thank you, Sophie, for the introduction. Good afternoon, everybody. I will talk you through the next two parts. I will start with trade secrets and intellectual property rights. They're the same, but also different. As Sophie has said, it's often used as a synonym, but it's very important to remember that they are not. I will look at the different intellectual property rights with you to see for yourself. So first things first, what are intellectual property rights? Intellectual property rights, they protect the creations of the mind. So as you can see here on the slide, we make the distinction between industrial property rights, sui generis rights, and literary and artistic property. We have patents, trademarks, designs. I think that speaks for itself. We have sui generis rights, so rights especially for computer programs and databases. And then we also have copyright for literary and artistic property. General characteristics of intellectual property rights, they are exclusive rights. So it's often said that intellectual property rights do give you a monopoly, but that's a very strong word. So we rather speak of exclusive rights. So that means in specifically when you have an invented, a patented invention, for example, only you can reproduce that invention, only you can export that invention, only you can distribute that invention, and so on. The same with a book for copyright. If you have written a book that is subject to copyright, only you can reproduce the book, only you can translate the book into other languages, and so on. So an exclusive right that is opposable erga omnes, so against third parties. And the downside is that it's a protection for a limited period. Like a downside, if we compare it, of course, to trade secrets, because trade secrets are enforced for as long as the secrecy is in place. In return for disclosure of the work of invention, so there's a kind of trade-off. You will get your invention, or you will get your patent, and so on, and your intellectual property right, but in return you need to disclose the work or the know-how behind the invention. And at the expiration of protection, the know-how falls into the public domain and everybody can use it. Now, let's go through the different intellectual property rights in specific. So let's talk about patents. The object of protection is here functional works or inventions. And what is an invention? An invention is a technical solution to a technical problem. I think with the COVID crisis that we all have a sense with the vaccine and the discussion about patents for that. I think we have heard it now. The term of protection is 20 years from filing, but it can be prolonged in certain circumstances for medicinal products. And then we talk about an SPC, but that's rather technical, so I won't go into that right now. And you will get your patent for 20 years, but you will need to pay annual fees, and they become more and more expensive over the years. What are the conditions then? So it needs to be about an invention, and that invention needs to be new, so it may not be part of the prior art. It needs to have an inventive step, so it may not be obvious to a person skilled in the art. And that's logical, because we don't want to grant patents for every type of invention. We want some inventivity. We want the community to benefit from it. And the invention also needs to be able to be industrial applicable. What that may be, it's broadly understood. Lastly, there's a registration formality. So as I've said, it's the kind of trade-off. You will get your patent, but in exchange, you will need to register the information, the know-how behind it, and so on. And then a last point that I see here is that the Code of Economic Law, the CEL, expressly identifies things that are not considered to be inventions. For example, aesthetic creations, because aesthetic creations are protected by copyright. And that is something that I want to remark, and as Sophie has also said, well, it's often said in the press, and there's a lot of confusion about what different types of intellectual property rights there are. Patents is only for invention functional works, and as we will see, a copyright is for aesthetic creations. Then you have also things that are, in a way, inventions, but that are not patentable because, for example, they go against the morality, and then we can think about processes for cloning human beings and so on. That was patents. And now we go to copyright. So the object of protection here is literary and artistic works. Literary works are everything that can be put into writing, so books, comics. My presentation now for you today, if it fulfills the conditions that we will talk about. So it's very broadly understood. Then you have artistic works, and artistic works is also understood on a very broad basis. You have paintings, photos, movies in all its aspects, the scenario, the screenplay, and so on, regardless of their artistic merit. Now, I said, well, intellectual property rights, they do grant you an exclusive right, and here we make the distinction between economic rights and moral rights. The economic rights are related to the exploitation of the product, so that, for example, the book, again, I've written a book, and only you can translate the book into other languages or adapt the book into a movie. So related to the exploitation of the work, and that can also be transferred to others. And then you have the moral rights, and they are related to the person of the author. So, for example, an integrity right, that the author can oppose a destruction or a modification of the work, and so on. The term of protection is rather long, so it's 70 years after the death of the author, and the conditions are twofold. The work needs to be original, what that may be. So it's an undefined subjective criterion, and it's often referred to as a stamp. It needs to possess the stamp of the author's personality. And besides that, it needs to be put into a form. So that means concretely that ideas, concepts, methods, they cannot be protected. And that is an important thing to remember, because we see some confusion in our practice regarding that matter. As you will see, there is no registration formality. So it's an automatic right when the two conditions are fulfilled, but sometimes it can be a good idea to file the work to get a secure date, but that is more for evidentiary reasons. Would there ever be a problem? Trademarks, I think also that speaks for itself. We come across trademarks multiple times a day. These are distinctive signs that are able to distinguish your goods and your services from the goods and services from somebody else. The term of protection is 10 years, but can be renewed, and they're also subject to conditions and a registration formality. Designs. So the design protects the appearance of a product or a part of a product. So again, a patent is for an invention, a design is for the appearance of an invention or of a product, and a term of protection is 5 years but can be prolonged. And the conditions are that the design needs to be new, it needs to possess individual character, and it is also a registration formality. Then we come to the very specific rights, so computer programs. What is a computer program? Well, it's software, it's preparatory material, program elements, and so on. And here the law clearly states that computer programs are to be considered as literary works, so they are protected by copyright if they fulfill the same conditions, of course, like originality. And the term of protection is also 70 years after the death of the author. Lastly, databases. What is a database? It's a collection of works, data, or other elements that are arranged in a systematic manner and that are accessible individually by electronic means or otherwise. So by an electronic search tool, a file plan, and so on. Databases can be protected by copyright protection or by sui generis protection, but for the copyright protection, it's only the structure of the database that can be protected if the structure shows originality. And of course, the independent elements within the database can be protected by copyright if they fulfill the conditions. Then you have the sui generis protection for database. It's a specific database right, and this is a protection for the content. So for example, that the right holder can oppose that somebody else reproduces or takes a substantial part of the content of the database, but then you will need to prove that you have put substantial qualitative or quantitative investment in obtaining the material, verifying the material, and presentation of the content. More important now is, why should you opt for one or the other? Which way to go? As said, trade secrets are no intellectual property rights. And depending on whether the information is kept secret or made public, the know-how can either be a trade secret or intellectual property right. So as Sophie has explained, trade secret can be all kinds of information, and that information can be considered as know-how that can eventually, for instance, be patented. So it's your choice. Oh, I was a little too fast. And I've made a table here where you can compare the two concepts. So trade secrets, intellectual property rights, as Sophie has explained, it doesn't grant you a real exclusive right. Intellectual property rights, they do. However, there are some exceptions, for example, for research purposes, but I'm not going into that in detail. The publicity is also different. As I said, and as I stressed, well, the difference in protection in time for trade secrets, they remain protected for as long as the secrecy has not been lifted. Intellectual property rights are granted for a limited period of time. The presumption of validity in case of infringement cases and the cost is also, in my opinion, an important aspect. For intellectual property rights, the costs can be, for a patent, for instance, you will need to pay a patent attorney to draft the patent because it's a rather technical question. You will need costs to register, to renew, and if you want to scan the market for potential infringement, of course, you also need to pay somebody to do that. For trade secrets, the costs are mainly internal and are related to the reasonable steps that I will explain hereinafter. Why you should choose for one or the other is a strategic question. So it's very difficult for us to say, well, you should do it because of that. It's your company, your industry that is important that you need to think about. So for example, the technical areas considered, to put it quite boldly or plainly, the florist on the street or the supermarket on the street will have other trade secrets than a pharmaceutical concern or a software company. So it's a personal impact. And the question is also how easy it is to discover the trade secret, either via reverse engineering or independent creation. And if that risk is high, maybe it's better to opt for intellectual property rights. But these are questions that you can ask yourself. And that you must ask yourself. So there is a concern for consistency because once you have chosen for an intellectual property right, the choice is irreversible. The secret is out, to say it like that. And in space too. So you need to guarantee your secrecy throughout your company and throughout the world. And a point of attention is also to keep evidence of the use of the trade secret to benefit from prior use rights in case there would ever be a counterfeit action by a third party. This brings me to our third part of the presentation, so I will talk you through the reasonable steps to be taken to create and maintain the secret. As Sophie has explained, the cumulative conditions, it needs to be secret, it needs to have commercial value because it's secret, and the trade secret holder must implement reasonable steps to keep that information secret. But what are reasonable steps? That is the topic of this part. Reasonable steps are important because it's very difficult to prove a secret, because a secret is a negative fact, and with the introduction of reasonable steps, you can in fact lower the threshold a little bit for the trade secret holder. He can show or he can prove, well, I implemented this measure, this measure, this measure, to show that he really took care of the secret. And it's an objective criterion. So as Sophia stressed, it's a case-by-case analysis. We think that it's best to do this exercise in 3 steps. And we speak of a protection chain to control the risks of deliberate and unintentional acts. First of all, identify the information that is being circulated within your company and classify that information. Is it sensitive? How sensitive is it? And so on. Identify, classify. In the next step, you will, if you have classified the sensitive information, you want to protect that sensitive information. How do you do that? With contractual means, physical means, IT means. And then in the third step, you think more globally about your company in an organizational way. So how are you going to put all the tools, protection tools together? And remember that rules are not sufficient if they are not effectively applied. So first step, identification and classification. Identify the information that is being circulated within your company. There are a lot of categories of information, of course, regarding R&D, products, regarding customer projects, suppliers, production, quantities, recipes, formulas, regarding marketing, customers, very important, and also a lot of internal data. So know which information that you are dealing with, and is also, of course, subject to your company and your industry. After that, you have identified your information, classify the information, because not all confidential information has the same value. And it's better to classify the information according to levels of confidentiality, according to the harm that may cause when there would ever be a confidentiality breach. So take the document and think, okay, if this document would ever come out or made public, would my reputation be compromised? Would it have an impact on my revenues, my current revenues, my projected revenues? Would it make me lose my competitive advantage, and so on? It's also important to do the exercise regularly because the information keeps evolving, of course. And we put it in a sort of scheme, and I think this makes it more clear. Identify the information and then classify. And according to how much or how hard the harm would be, you can use with different stamps on the document. I think, or we think that using stamps for your documents, like for internal use only, confidential, classified, is a cost-friendly but a really effective way to let the people in your company know this is important, this may really not leave the premises, and so on. So different types of levels, and you can use with different types of codes to classify the information. That was step one. So we have classified information, and what do we do now? So we want to protect it. We want to protect it with contractual means, we can protect it with digital means, and we can protect it with physical means. And the goal is, of course, to control who has access to the documents, who can transfer the documents, who can make publications or communications about the documents. And it is pointed towards contractors, subcontractors, employees, competitors, of course, opponents. Because if you look at the case law, and we don't have any voting buttons here, but if we would ask you, well, who would breach all the, if there would ever be case law, or the question would be, sorry, who would breach the secrecy more often? Is it an opponent? Is it a competitor? Or is it an employee? The most cases are about employees. So we think that it's very important to think about external threats, to put it that way, but it's also important to have internal policies in place to protect your sensitive data from leaving your premise. So look at the first protection tool. So we have classified and identified our information, and now we want to protect it either via contractual means, so use NDAs, non-disclosure agreements at the negotiation stage, and afterwards in your main contract. So with your employees, suppliers, clients, use confidentiality clauses, use in certain cases non-competition clauses, or as Sophia said, use a clause that prohibits the reverse engineering. So there are a lot of things that you can think about, and maybe it's easy to use with it, or to use a checklist. So identify the parties to whom the information will be communicated, and what is your purpose, what is your intention, what do both parties expect, and define in a very clear way what confidential information is and what confidential information is not, so that there can be no discussion about it. What is the duration of the confidentiality obligation? Is it better to implement a license agreement or to use a license agreement? Should we prohibit reverse engineering, as I said, and so on. Interesting is also to organize the end of a contractual relationship regarding the return of the sensitive documents, maybe organize an exit interview with your employees, and so on. Be creative. Physical tools, protect your sensitive data via physical tools. Regarding members of your company, this all seems very logical. So use logs, access badges, maybe work with the need to know principle. So this sensitive document, is it really necessary that the whole company has access to it on the internal server? Use clean desk policy, use an information stamping, as we have explained. Work with a copy policy, document destruction policy. These are really effective ways, and they're rather cost effective or cost friendly. And then towards third parties, you can use with visitor registration, visitor identification badges. Sometimes it's also interesting to ask your visitors to store away their camera and their smartphone, or to block it. So be creative again and think about what is more important and most effective in your case. And then lastly, the protection tools digital. So what IT measures can you implement to protect your sensitive data? You can work with limited access rights, logins, passwords, of course, also very logical. Use encryption systems, use disclaimers, maybe destruction of information after a certain period of time. So again, we're not going to say that you need to do this or this or this. Think about what is best and most effective and most efficient for your company. Now, the third step, the organizational measures. So more globally, you want to provide your company members information, and you want to ensure that the other measures are applied effectively. At company level, different possibilities. You can adopt a confidentiality board. You can involve and inform the business. What do they expect? What can be done better, and so on. Adopt and publish a code of conduct. Internal regulations where you, for example, implement a copy policy, a clean desk policy, and so on. Provide for and, if necessary, apply sanctions. I think that speaks for itself. Also at business level, define your responsibilities, train your personnel, talk with them about it, maybe use code of conduct. And as mentioned, the exit interview can also be a good way to deal with sensitive information after the contractual relationship ends. Lastly, let's look in practice. So as we have seen, and as Sophie has explained, it is on a case-by-case basis, and it was a case in the Ghent Commercial Court that was about technical product information. And here the court has made an interesting definition about reasonable measures. Here the court said, well, reasonable measures are obvious technical and legal measures to shield information from interested parties for whom it is not intended. And I think it's a very concise definition, and it says it all. What is obvious in a technical and legal sense for your company, for your group? And here the company used IT infrastructure with limited access, secure login and password, and also used contractual confidentiality obligations. And the court said, well, these were indeed reasonable measures for this company. In the second case about setup of production lines, here also the court has said, well, the reasonable measures are sufficient, even though, and that's interesting, even though that alleged infringer, who was an independent service provider, was not bound by any written agreement or confidentiality obligation, because the court said other measures are sufficient. They also used limited access rights. They stamped their documents. So again, it's a case-by-case basis, and the definition of the Ghent Commercial Court says it all. And now let's go to the last part of our presentation.
And I'm back. I've seen there is one question has been asked, and if you allow us, we'll answer after this section, so that if other questions comes in the meanwhile, we will answer them all together. So bear with me. So this last section, as I said in the introduction of the presentation, is to show you more on a judicial point of view, which tools you have at ends in order to protect your trade secret in case of misappropriation, so to protect it, and also, if necessary, to obtain reparation in case of infringement. Don't worry, I won't go into the details here. The idea is really to give you a general overview and to let you know that there are things in place to protect the trade secret and judicially to get things redressed if possible, or at least to get damages. But the idea is not to go deep into the procedural elements and explain you everything. And also you will receive the presentation, so if we go too quickly over some elements, you can always read, whenever you have time, if you want more information. So first, you have provisional and conservatory measures that you could try to get in order, if you are aware of a possible of an alleged misappropriation, then you could try, because provisional and conservatory measures go quicker. So in case of infringement or misappropriation of a trade secret, it's always better to go for that first, if it's still useful, because sometimes it's too late, so sometimes it won't be necessary to go that way. But when it's still useful, then go for provisional conservatory measures, which will go quicker. So what can you get through this way of action? I will skip the first line. So for the seizure of evidence, we'll come back to that in one slide. You could seize the infringing goods, for example, and you get them out of the market. You can provisionally seize the infringement, seize the misappropriation. So try to stop the damage to get bigger and limit it. Even though the damage is already done, sometimes it's good to limit it because it could always be bigger. And you can also at this provisional level get penalty payments, which is quite useful to dissuade the misappropriator, the infringer, to do more harm. How can you get those measures? You can go two ways. You can go the inter partes way. Inter partes is the way contradictory way of proceedings, which is the most usual, certainly in Belgium, and I guess in more, if not every country in the world, that when you attack somebody, that person should be able to defend itself, so it should be contradictory. And ex parte is when you, and here it would be the trade secret holder, could act unilaterally in the first place and get some kind of measures in place, and then those measures will be applied, will be enforced against, the infringer. And at that point of enforcement, then it becomes contradictory, because when the measure is implied, is enforced, then it's you're aware of it and it's not unilateral anymore. Then the Belgian legislator, and also because it was requested in the directive, you were invited to follow the directive, put some specific measures to revoke the measures, and or to say that it will stop to have effect in some specific cases. It is that in order for those provisional and conservatory measures, to be able to go on, the trade secret holder have to file in an action on the merit within a specific period of time. It is in order, to avoid that the trade secret holder will go that quicker route, and then will just let the infringer, in the dark, not knowing what he has done, to what he will exactly be found guilty of. So you have to go on the merits afterwards if you want to maintain the measures that you obtain. And if the information loses trade secret quality, so if the conditions are not met at one point in time, at some specific point in time, and then the measures will fall down too. And of course, it cannot lose this trade secret quality because of the defendant, because it will be one even further misappropriation. But if for other reason, then the measures will stop. Then there is an alternative. I won't go into the details, but in some specific cases, the judge, the court could find that the measure shouldn't be awarded, but that the defendant could pay some specific amount that wouldn't be damages yet, but kind of some specific kind of damage, even though you're not on the merit damages, to pursue the unlawful use. But of course, you must. It's not. How do we say that? It's not a go to just disclose the secret information. It's a go to keep on using it. If the infringer kind of show that he won't disclose it, he's the only one using it, and that there is some kind of fair compensation to the holder in avoidance for the proceeding on the merits. And the plaintiff could also be held liable in some cases when you go through these provisional and conservatory measures, and you get those provisional measures and you enforce those measures, but that it can cause harm to the third party, it can also cause harm to the defendant. So in some cases, the court will ask the plaintiff to pay a guarantee in order to make sure that if it is later on, if it appears that those measures were not justified and that they caused harm to the defendant, then we'll use this guarantee to pay at least part of the damages for the defendant harm. And if after the execution of the measures, the plaintiff could be also condemned to damages, and those measures could be revoked, as we have already seen. And then specific, and it's quite important, and maybe even more for those of you who are familiar with IP rights, is that in IP rights we have a specific kind of discovery. It's not a discovery measure, but it's parent to the US discovery measures. Is what we call descriptive seizure measure, and it's a measure which all the IP right holders they can get. And it's an easy measure to get. It's a unilateral measure to get. You go to the court unilaterally and you explain why you have suspicions that your right is infringed, and the court will give you, of course, you have to show some kind of indication of the infringement, and the court will give you an order allowing you to go on premises of the alleged infringer and to gather evidence of the infringement and so on, and then to go on the merits. And this descriptive seizure has not been retained for the trade secret protection for a lot of reasons. First of all, because trade secret is not an IPR, because it was decided in the trade secret directive to not go that direction, because I guess it was too touchy, and also trade secrets make it more touchy, because it's less tangible than a specific. Sometimes it's less tangible at least than a specific IP right. You know exactly what you have. For trade secrets, sometimes it's hard, you know, to define and to really identify what you are talking about. And so the Belgian legislator was afraid that if you open right away the descriptive seizure for trade secret, you could have what we call fishing expeditions. So you go for one thing and then you go and you fish anything you find on the alleged infringer premises. But in practice, we found out finally that we can get, well, not the same thing at all, but quite the same thing. So you go for an ex parte measure through the provisional route, which is in summary proceedings, and you have to show, so that is the condition that is mainly different from the descriptive seizure, for which you have to show no urgency, nothing. But here, through that ex parte measure specific route for the trade secret, you have to show absolute necessity or extreme urgency to act. So that's one additional condition that makes things a little harder for the trade secret holder. But for the rest, it will, when you get the order, it will be almost the same as the descriptive seizure. So you will get a bailiff and a court-appointed expert that go on premises. The expert make a report, you know, gathering evidence of the alleged misappropriation of your trade secret. And the defendant, so the seized party can, when it becomes aware of that, when he sees a bailiff on its door, he can oppose this order in a third opposition party proceedings. And here, as for the descriptive seizure, it has absolutely to be followed in a specific short period of time by an action on the merits, and if not, you will lose the benefit of the expert report. So that's it. And so on the merits, it will go quite fast, because here it's really to show you the general picture, and it's not really different from what exists on the IP right. It's quite similar from what you can get for IP right measures. You can first have the cessation of the unlawful act, and you can get that through a cease and desist specific action, which goes a little faster, but where in this specific action you can only have the cessation of the act. Or you could get the cessation of the unlawful act through the more normal proceeding on the merits. And here, if you go the normal route, you can get cessation and damages. And around the cessation, you can have any some other measures like recalling of the infringing goods, the removal of the infringing character of the goods, and so on. All those little additional measures that will contribute to make the infringement, to make the misappropriation, to cease. And the cost of those measures, if there are any costs, are to be borne by the infringer. You have also possibility, it's a little bit like we have seen on the provisional side, a possibility for the infringer to ask to not have a cessation measure pronounced against him, but to pay some kind of amount to allow him to keep on using the secret in some specific circumstances, and that would be on the merit. But here some really specific conditions are defined, but that's worth knowing that it is possible. And then next to the cessation, if you go the normal route, because I've said the cease and desist action, it's only cessation, but the normal route, you can also have not only cessation, but the compensation of the damage you suffered. And here you can be compensated for any kind of harm you will suffer as a result from the misappropriation of your trade secret. And there is no requirement of knowledge in the infringement part. Ooh, the presentation stopped. Wait, I don't know what happened. Ah, okay. Well, hopefully it didn't stop now because I touched something, but I don't see my slides. But anyway, so compensation, so no knowledge needed. That's okay. I found my slide back. Sorry. No knowledge needed, and compensation in full or in part, or a lump sum. If you cannot show, exactly how much money would compensate you, you can go for a lump sum. And there is damages, so you can be paid, money, or you could also ask for the delivery of the infringing goods in some specific way. Then, sorry, the publication measures, it's important, so you can ask for the publication of the judgment, which the defendant will not like, because of course it's always bad publicity, but you cannot only do it because it is bad publicity, you have to show to the judge that this publication measure you request will in some way contribute to the cessation of the misappropriation of the infringement, so to make it stop. If it's only to go against the defendant, normally it won't be granted, and that's why the last point when you see publication measures is balance of interest. So the judge will always also make sure not only is it justified to make the infringement cease, but also it does not cause damage to the defendant in some enormous disproportionate way. And you can also get on the merits some penalties payment. And then the last point, when we go through those more judicial analysis of what you have, is that we have seen, well, not me, but I have read that one of the main deterrents for trade secret holder to act before, because a few years ago there was almost no cases of trade secret, not only in Belgium but in in a lot of countries. Well, no, there are a little more cases. It was not the huge boom that we expected, but it's coming more and more. But why was there almost no cases? Is that because the trade secret holder was afraid to make more harm than good, because if he comes to the court with a secret, it will have kind of to disclose a secret, to show the court what is the secret, and to explain it, and take the risk that other people will get this information, because in Belgium and in most, I guess, European countries at least, and many other countries in the world, the judicial proceedings are public, and there is a lot, everything to make it transparent, and so that we know that the justice is not for the privileged but is accessible to the public. Then you have the risk that your secret will get lost in the way. And here, before the specific law for trade secret, the judge were already trying to be creative in order to reassure the trade secret holder and to show that his secret could be protected. But with the law, the things are really clearer, and it gives really a good framework for to protect the secret. And it's important to note that contrary to the directive that asks for protection only for protection to be put in place only for the proceedings that were specific to trade secret, the Belgian legislator took the opportunity to not only put protection in place for these kind of specific proceedings, but to open it for any kind of proceeding within which a trade secret will come on the table, even though the proceedings to begin with was not, directed specifically to the trade secret. And so there are specific measures that have been put in place. First of all, is all the people participating to a proceeding in whatever quality. So even the bailiff, even the clerk, person working in the clerk office, all this person who directly and indirectly will have knowledge of information shared within the proceedings will be held by some kind of confidentiality obligation, and that will be put in place on request by one of the party, generally, or ex officio, that the judge can ex officio decide this information is really sensitive. We will put some kind of confidentiality obligation in place, and this confidentiality obligation covers, of course, all the proceedings, but will continue after the proceedings, and will only end when the information considered is not secret anymore, in the trade secret legal sense of the word, or because it was not a secret, or because it has lost its secrecy over time. And so there is this general confidentiality obligation, and then there's two other measures more specific that can be taken. Is that we can put in place what is called confidentiality club. Is that we will identify specifically who within the parties, who within the lawyers can take knowledge of some specific documents, who can access the hearings, and only those persons will then be shared this specific information. So once again, it's on request or sometimes ex officio by the judge. And next to that confidentiality club measure, we can also, and that will be sometimes complementary, because the person who are not part of the confidentiality club will only have access also sometimes to a non-confidential version of the judgment. So you have a judgment where the judge will redact some specific part of it, so that the confidential information is not, potentially lost. And all those confidentiality obligations are under possible sanction of a fine if you don't respect it. So that was, really broad general overview, quite quick. I hope it was okay for you to follow. I was going to jump to the Q&A. Just note that, of course, for like any kind of judicial action, you cannot act forever. You have to act within a specific period of time. I'm not going to go into the details, but it's generally speaking, it's 5 years from from the time the holder has knowledge of the infringement and of the infringer's identity. He has 5 years from that time to act. And in general, because we have, he can, of course, kind of go around the truth, says, oh, I just learned it, and it's not true, we knew it from 20 years, and there is a specific time limit. It's 20 years after the fact, whether you knew it or you don't know it, it's over, and there is some specific timing to be respected when it's a cease and desist action and when it is concerned an employee. We are really thankful to you for joining us this afternoon, and hopefully you learned some things, well, hopefully we can see you in person really soon, some other time. Have a good afternoon. See you.